Ladies and gentlemen, today's courtroom hearing is a perfect example of how a single decision can change the course of someone's entire life. What starts as a routine discussion about competency quickly turns into a high-stakes legal showdown involving serious felony charges, prior convictions, and a plea offer that could mean the difference between 7 years behind bars and spending decades in prison. The judge is faced with defendants making choices that will impact not only their futures but potentially the rest of their lives. As you'll see throughout this hearing, the court repeatedly emphasizes one powerful theme. Every defendant has the right to choose their path, but every choice comes with consequences. Pay close attention because some of the decisions made today leave even the judge visibly concerned. One defendant is offered a deal far below the punishment he could face at trial. Another receives an opportunity focused on rehabilitation rather than incarceration, and later will witness a dramatic moment when a defendant's statements appear to conflict with his own sworn admissions. The tension rises with every minute, and by the end of this hearing, the courtroom delivers lessons about accountability, honesty, and the enormous risks that come with gambling on the justice system.
See, Mr. Rojas, you have Crystal Moore. That's numbers 23 DCCR 2026 and 25 DCCR 0496. This is kind of long. I needed to see this before. Let's see. Yeah, it looks like it. No, that's okay. I see it was just fine.
It's mine.
Good morning, you're Crystal Moore. All right, y'all give me just a second to go through a couple things here. All right, so are you asking for, I know so there's a motion to revoke probation in 23 DCCR 2026, and there's no bond set in that one, correct?
Correct.
And then in 25 DCCR 0496,
I think there's a $6,000 bond in there.
I showed $2,000 bond.
well,
Take two.
That's what I showed us.
can y'all help me figure out that real quick with the actual bond? I know you're not asking for that one to be reduced.
No, Judge.
So really, we're just talking about the other one.
The motion to revoke.
Okay, so on probation for DWI with a child passenger, and the new offense is a theft, correct? State jail felony?
That's correct, Your Honor. And there's also a case that was, she was arrested for possession of controlled substance that has not been filed yet.
Okay,
So
probably waiting on labs on that?
Yes, ma'am.
Okay, and that same date as the theft, or is that something different? Do you know?
I don't have anything.
Okay,
October of 24 is what my notes indicate on it.
And this was December of 24.
Well, I'm a little confused. I've got an October theft and I also have a November theft according to my summary of her criminal history. Both of them I list as.
Our indictment shows an offense date of December 26, 24.
I'm not sure.
okay, that's okay. So I want to make sure, and Mr. Coleman has filed a response, and part of that response includes the information that Ms. Moore was
This is where the reality of habitual offender laws becomes impossible to ignore. Many viewers hear the original charge and assume they understand the potential punishment, but prior felony convictions can completely transform a case. What may have started as a punishment range measured in a handful of years suddenly becomes a situation where a defendant could spend most of the remainder of his life in prison if convicted. Notice how carefully the judge explains the stakes. He isn't telling the defendant what decision to make. He's making sure the defendant understands exactly what is on the line. Courts take these moments seriously because once a defendant rejects an offer and proceeds toward trial, there is no guarantee that opportunity will ever come back. The judge is effectively saying, think carefully, because this choice could define your future. That's not courtroom drama. It's the reality of criminal sentencing when repeat felony convictions are involved.
Previously convicted of the offense of robbery, initially placed on a deferred probation that was revoked in 2017 on that case. Also a conviction for aggravated assault out of Tarrant County from 2016. And then we've got the probation that was granted here on the driving while intoxicated with a child passenger. Let me get this pulled up again real quick. And while on this probation has been arrested for two new offenses, the theft and the possession of a controlled substance. Is that?
That's correct, Judge. And since you got my motion, my reply, you've already read it. I'll just be brief. I just want to add that according to my recitation of her criminal history, it looks like she's got a total of 5 pending cases that include an unauthorized entry of an inhabited dwelling out of Louisiana.
I see that as well. And there, do you know if there's warrants issued for those? I know it's hard to get information. Do you know anything about those?
No, this is the first I'm hearing about that when I saw that in the motion. I don't know if there's any holds on her from Louisiana or not.
All right. Mr. Rojas, do you wish to call any witnesses?
Briefly, Judge, I'll call Ms. Moore.
Ms. Moore, best you can, raise your right hand. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead, Mr. Rojas.
Ms. Moore, where are you from?
Correct.
And have you lived in Port Arthur all your life?
Yes, sir.
All right. Who do you live with when you're not in jail?
My family.
Speak up for us.
My family, my mom.
Okay, and who all lives in the home with your mom?
Me, my mom, and my kids.
Okay, and how many kids do you have?
5 kids.
And what are the range of their ages?
My youngest is 1 and my oldest is 11.
And is your mom taking care of those kids right now?
Yes.
Okay, and my understanding is that your mom is also ill right now?
Yes.
What is the nature of her illness?
She has a brain tumor and has to undergo treatment and surgery.
And is there a surgery scheduled for that already?
Well, she actually postponed it due to she has no support with my kids right now.
Is she the only adult in the home with your kids?
Yes.
All right. And that's one of the reasons you want to get out, to make a bond in this case so that you can go out and take care of your kids, make arrangements for them, because your mom's going to have some surgery and she won't be able to do it anymore.
Yes.
All right. Do you have any income when you're not in jail? Do you have any income coming to home for you?
Yes.
What do you have?
SSI and child support.
SSI, how much do you get in SSI benefits?
1,000.
Is it every month?
Yes.
And child support, how much do you get?
140
How often is that?
every 2 weeks.
140 every 2 weeks, so that's $280 a month there. Do you have a bank account in your name?
Yes.
This exchange highlights something many people outside the legal system find confusing. The difference between pleading guilty, pleading no contest, and pleading not guilty. The defendant appears to want the benefit of accepting a plea arrangement while still maintaining a position that doesn't fit the legal process being discussed. The judge takes time to explain the options because courts want defendants to make informed decisions rather than decisions based on confusion. What's interesting here is how patient the court remains despite the high stakes involved. A misunderstanding at this stage can have lasting consequences, and the judge is attempting to ensure the defendant fully understands what each plea means and what legal effects follow. Viewers, put yourself in this situation. If your freedom potentially depended on a single legal decision, would you take the deal, or would you risk everything at trial?
Do you have an idea of how much money is in the account right now?
Probably like 500.
Do you own any property that you can sell to help you come up with money for this bond?
Yes.
Is your mother or any other family members, are they willing to help you come up with money to make the bond, the judge has set a bond for you?
My mom, so she can proceed with her procedure.
Your mom's willing to help you out?
Mm-hmm.
And that's what you're asking the court to do this morning, set a bond on the motion to revoke on this DWR, right? And the main reason for that is so that you can get out and help your mom take care of her kids and get her past the surgery.
Yeah, like I understand that in the future I might have to serve time for my actions, but that's like my goal was to get out so she could undergo treatment, and I could fully prepare her and my kids for when I do have to serve time.
Pass the witness.
No questions for this defendant, Judge. I stand on the motion. I don't have anything to add to the motion. If the court's inclined to grant this defendant time, I just simply ask you to consider the factors listed in that motion, Judge.
Well, I'm looking back just for everyone, for the record, at the pre-sentence report that was prepared in cause number 23, 2026, and I've reviewed that. I've also reviewed, there's a handful of jail incident reports that everyone was given a copy of as well. Based on the nature of Ms. Moore's prior convictions, which range from, give me just a second to go back out through this, beginning as a juvenile, back in 06, 07, extending all the way through 2012 as a juvenile, assaults, thefts, violation of court orders, and then we get into adult, and we've got more thefts, county jail, theft of property, then we get into felony, we've got a robbery, given a probation, that was revoked, we've got a theft from a person, and then we've got an aggravated assault with a deadly weapon, that one from Tarrant County. Now on probation, given all the opportunities, multiple allegations in the motion to revoke probation, that Ms. Moore has not apparently done much of anything while on probation to get the help that we've been offering her, in addition to having 2 new offenses, a possession and another theft. I find that it is in the best interest of our community that there not be a bond set in cause number 23, DCCR 2026. I appreciate the arguments, and I feel and have empathy for what your mom is going through, but you should have thought about that before you kept doing what you were doing. So you can go back with the bailiff. I'll set the case for an announcement on the motion and the new case.
Thank you, Judge.
I was eavesdropping. Okay, Miss, again, you're Crystal Moore. And Mr. Rojas, will your client waive the formal reading of the indictment and the motion?
She will, Your Honor.
Ms. Moore, in cause number 25, DCCR 0496, you're charged with that's the new offense. You're charged with theft of property with previous convictions, a state jail felony from December 26th of 2024. That indictment alleges that you were previously convicted of theft April 28th of 2017, and then after that was final, March 5th of 2024. And how do you plead to that charge? Are those 2 prior convictions true?
Yeah.
Did you enter your plea of guilty freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they charged you with?
Yes.
I have some documents in that case here on the computer that this has your signature on it, that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand?
And there it is, the moment that could define the entire case. The defendant has effectively chosen to move forward toward trial, and with that decision comes the loss of a plea offer that was dramatically lower than the punishment he could face if convicted. This is one of the biggest gambles we see in criminal courtrooms. On one hand, every defendant has the constitutional right to maintain innocence and demand a trial. On the other hand, trial carries risk, especially when prosecutors believe they have strong evidence. The judge repeatedly reminds him that he is presumed innocent, but he also makes sure the defendant understands the potential consequences. This is the kind of crossroads that legal analysts talk about constantly: certainty versus risk. The 7-year offer is gone, and now the future becomes far less predictable.
Them.
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Okay, so it looks like we are
Proceeding on.
off of the
Counts.
ISF issue or whatever.
Oh, okay.
Right.
I don't think that was.
ever.
That wasn't this one. Okay, gotcha. Sorry, I don't know why I'm getting so confused. Again, but before you signed these, you went over them with Mr. Rojas?
Yes.
All right. And do you understand, if I follow the agreement, that you'll be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement that you made, you understand?
Yes.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Moore is not competent?
No, Your Honor.
All right, ma'am. In cause number 25, DCCR 0496, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions, sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It's my understanding that the state has taken into consideration under Section 1245 of the Penal Code that unfiled possession of a controlled substance, which means, Mr. Coleman, y'all do not plan on filing that. Is that correct?
That's correct, Judge.
All right. So then, in cause number 23, DCCR 2026, I have a motion to revoke your first amended motion to revoke your community supervision in that case. It shows that you were placed on probation April 29th of 2024 for the offense of driving while intoxicated with a child under 15, a state jail felony, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes.
The state has elected, or the agreement that you've reached is for me to go forward in that motion with counts 2, 3, 12, and 13. Is that correct?
Yes.
Yes, Your Honor. And the state would abandon the remaining.
Thank you, Mr. Coleman. Ms. Moore, count 2 alleges that you violated your probation in that you were in Calcasieu Parish, Louisiana on the 22nd day of November 2024 without permission. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample October 9th of 2024 that tested positive for benzodiazepine and tetrahydrocannabinol. And is that true or not true?
True.
Count 12 alleges that you committed the new offense of theft of property October 18th of 2024, and is that true or not true?
True.
And count 13 alleges that you committed the offense of possession of a controlled substance February 26th of 2025, and is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 12, and 13 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
So I also have paperwork here on the computer in that case that has your signature on it that the state's marked as exhibit number 1. Did you also go over this with Mr. Rojas?
Yes.
Do you fully understand it as well?
Yes.
And you also understand that if I follow this agreement that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted.
What makes this next case so interesting is how different it is from the one we just witnessed. Instead of escalating punishment, the court is focusing heavily on rehabilitation. The original robbery allegation has been reduced to a lesser offense through negotiations, and the resulting agreement prioritizes probation, supervision, and substance abuse treatment. This is a reminder that not every criminal case ends with a lengthy prison sentence. Courts often look at factors such as criminal history, cooperation, recovery of property, and opportunities for rehabilitation. The goal is not always punishment alone. Sometimes it is preventing future criminal behavior. The judge carefully explains the conditions because probation is not a free pass. Violating those conditions can lead to serious consequences. Still, compared to the earlier discussion of decades in prison, this outcome demonstrates how dramatically different criminal cases can be depending on the facts and circumstances.
Ms. Moore, in cause number 23, DCCR 2026, I'm going to find that you entered your pleas of true to counts 2, 3, 12, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find sufficient evidence to revoke your probation, and at this time revoke your probation and reassess your punishment to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive, and it will run concurrently, this case, with cause number 25, DCCR 0496. In each of your cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We went over that not that long ago when you were placed on probation the first time, right? Do you recall that?
Yes.
Okay, so you're, obviously because of the judgments entered against you, you're ineligible to possess a firearm in the state of Texas. We've already gone over it. Make sure you read it. If you have any questions about it, talk to Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. Okay, that's done. Good morning. Are you Reagan Howard? And this is 22-39924. And give me just a second. Miss Howard is on probation for deadly conduct, discharging a firearm. A motion to revoke that probation has been filed. There is not a bond at this time. There's been a motion asking that I set a bond. And Mr. Kimler, do you wish to call any witnesses?
Ms. Howard, Your Honor.
Ms. Howard, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this case or hearing will be the truth, the whole truth, and nothing but the truth?
May I proceed, Your Honor?
Yes.
Ms. Howard, you understand you're on deferred adjudicated probation for third-degree felony offense of deadly conduct, is that correct?
Yes, sir.
You understand that that's punishable up to 2 years, or from 2 years up to 10 years in the penitentiary?
Yes, sir.
And a motion to revoke probation has been filed asking that the judge revoke your probation and sentence you within that range.
Yes, sir.
Are you requesting that pending a disposition of that determination that the judge admit you to a bond or provide a bond in the case so you could get out and attempt to resolve some of the issues that you're having on probation?
Yes, sir.
If the judge were to give you a bond in this case, where would you reside?
1950 Parkland Street,
In which city?
Beaumont, Texas.
And would you report to probation as instructed?
Yes, sir.
And do you have a job here, or what do you?
No, not yet. I'm trying to get one.
Pass witness.
Any questions of this witness?
Ms. Howard, have you been using drugs?
No, sir. Well, I smoke weed.
Have you admitted to the probation officer last week in jail when she came
yes.
to visit you that you have been taking?
Hang on, listen. Hold on.
Now we're looking at another defendant facing an enormous decision. The prosecution has negotiated an offer below what the defendant could face if convicted at trial. Yet the defendant remains uncertain. This is where criminal defense becomes incredibly difficult. Attorneys can explain the evidence, discuss possible outcomes, and offer recommendations, but ultimately the decision belongs to the defendant. Listen carefully to the numbers being discussed. A 20-year offer may sound severe, but when compared to a minimum exposure of 25 years and the possibility of life imprisonment, the legal calculation changes dramatically. The judge isn't pressuring the defendant. He's emphasizing reality. Everyday defendants across the country face similar choices, weighing hope, fear, evidence, and uncertainty. The question becomes simple but incredibly difficult. Do you accept a known outcome or risk everything on what a jury might decide?
One person talk at a time. Let him ask the whole question, and then he'll let you answer it, okay? Don't start answering it while he's still talking because the court reporter has to take everything down.
Yes, sir.
Okay.
So you have been smoking marijuana
Yes, sir.
and you haven't been reporting,
Yes, sir.
and you were ordered to go to ISF, substance abuse, and you refused to do that?
Yes, sir.
And we've offered it again today, and you refused to do that. No further questions?
If I might, Chair, just to be clear, you haven't been smoking marijuana while in the jail.
Oh, no, not in jail.
No, while you're out on probation.
Yes.
Just wanted to clarify that.
So it looks like there was an administrative hearing back on October 1st of 2024. I'm just gonna, that was, so I guess I'm wondering, this administrative hearing recommended the ISF, right? Yeah, and JCDI. And there was a number of violations. But all of these violations, for some reason, were not included on the motion to revoke, because the second administrative hearing, I guess, that came through only had the kind of some new allegations.
Correct. So what happened was the first administrative hearing recommended ISF with JCDI's aftercare, and then when she never turned herself in, we asked for the ISF warrant to be rescinded and the motion to revoke to be filed instead.
So if nothing else, I think the motion, I would believe that the state might want to go back through that previous administrative hearing and allege all of those things in the motion instead of just the two new, because those are obviously fell into report, which is the same as the second administrative hearing, but there's tested positive for alcohol, tested positive for cocaine, tested positive for THC, hadn't done anger management, didn't do the substance abuse assessment 2 different times. So, I mean, there's a lot more. If you just look at the motion right now, it only has 2 allegations, but it looks like it should have about 10 or 12 allegations. And based on all of those alleged issues, as well as the fact that Ms. Howard has just recently admitted that she was using drugs while on probation and not showing up. At a minimum, if I were to leave her on probation, she would be going to ISF or somewhere. So I'm not going to, I don't think it's in your best interest, Ms. Howard, that I'll let you out while this is waiting so you can go do more drugs and get in more trouble. It's obviously there's an issue that you have not been able to take care of on your own. So if you want to have any chance of remaining on probation, then that would be the only thing that I would consider doing. Otherwise, your probation is likely to be revoked if those things are found true, and you're going to go to prison for some amount of time. I don't know that that's where we need to get on this, but if I don't have any choices and you refuse to go get the help you need, then you're not going to give me any choice but to potentially revoke that probation. All right, so I'm going to, if there's some agreement that can be reached today, great. If not, I'm going to reset the case to I'm going to deny the motion for a bond. I think it is in the best interest of our community, and based on all of the factors in 17.15, the underlying offense being deadly conduct, the allegations of what has been and has not been taking place on probation, I am going to make the finding that it is best that a bond not be set at this time.
The state's offer was if she were to go to ISF, they would agree to continue her, or agree to recommend continue on probation. Ms. Howard's an ISF.
I mean, if she doesn't want to do that, she doesn't want to do that. I'm going to reset the case. I would ask the state to make sure and go through the motion. If there needs to be an amended motion filed.
We'll be amending our motion today or tomorrow.
Get that done quick. That way Mr. Kimmler has all of that. We can come back at a later date, go through the motion, get pleas of true or not true, and then we'll go forward at that time.
Yes.
You can go back with the bailiff.
Can I say something?
Yes, ma'am.
Is it too much to sign for ISF?
Talk to your lawyer about that. Good morning. Are you Kevin Harmon? And good morning, Ms. Holmes. Good morning. Will your client waive the formal reading of the indictment? Yes. Mr. Harmon, in cause number 24, DCCR 1612, you are charged with the second-degree felony offense of assault of a peace officer from July 9th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, okay.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea...
This may be one of the most important moments of the hearing. Rather than forcing an immediate decision, the judge allows additional time for reflection. Some viewers might wonder why a single week matters, but when a defendant is deciding between a plea agreement and a trial that could lead to decades in prison, every opportunity to carefully evaluate the situation matters. The judge recognizes the seriousness of the decision while also acknowledging that deadlines imposed by prosecutors cannot be ignored forever. Notice the balance here. The court respects the defendant's right to choose, yet also understands that criminal cases cannot remain unresolved indefinitely. This extra week may not seem significant, but for the defendant it could be the most important week of his life.
If guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. Speak up. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harmon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. And that'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond?
I do have one concern, Your Honor. The call where this happened was a family violence choking incident. He was charged, I believe, with family violence burglary with intent to commit assault. Those cases were not pursued by the complainant, so they're not pending or anything. But if he gets released, I just want some kind of safeguards in place.
Well, they didn't file the cases, and then I don't know that I can. Where are you going to live when you get out, Mr. Harmon?
I was living with some people that was just friends with.
I cannot understand
I was
you.
living with some people that was just friends with.
Right.
And my mother, so that's why I was going back to.
But that's where all this happened?
No.
No, this is a different place. Okay. So if I let you out today, I want to, what's the name of the friends that you're saying that you're going to live with?
Arlie Woods.
Say it again.
Arlie Woods.
Arlie?
Iron Lee Woods.
Iron? How you spell it?
Spell the first name.
IRAN.
Gotcha. Last name Woods?
Yes, ma'am.
Okay. So at least while this is pending, if I let you out today, I'm ordering that you live with them and not at the other place where all of this happened.
Yes, ma'am.
Okay? Maybe later, if everything's going well and you want to have some relationship with whoever this was, I'll get more information about that in that pre-sentence report. We can talk about it at sentencing. But what I'm going to do today, because of your plea for probation, is I'm going to reduce your bond in your case to $1,000. So if you're able to make that bond, there's a couple of things that are very important. The first thing is that if you make the bond, you go directly to the probation department so they can start that interview process for your pre-sentence report. If you don't go there and do that, then you run the risk of me not accepting this plea agreement and things could be much worse. You understand? Also, a condition of that bond is that you are going to live with Iron Woods. No one else until either I give you permission or we discuss it again. You understand? Also, if you are arrested for anything, if you make that bond and you're arrested for anything before you come back for sentencing, obviously things could go. I don't have to accept this agreement. Okay? All right. See you at sentencing.
Thank you, Your Honor.
Thank you, Mr. Nichols. Good morning. Are you Michaelan Jones? And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your...
I'm sorry, just
Oh, that's okay.
really want to count 2, 3, and 4 whenever you get to it.
Thank you.
That is correct. Thank you, Ms. Jordan.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point Coupe in Louisiana. And is that true or not true?
Yes, ma'am.
True or not true? Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
And then count 4 alleges that you committed the offense of possession of a Schedule I drug on May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
The motion was filed in June of 2023 based on offenses that happened in May of 2023. He's been in Louisiana custody since those offense dates of May of 2023. However, our hold for this motion to revoke didn't get placed on him until October 7th of 2024.
And Judge, Mr. Rojas, I'm sorry to interrupt, Mr. Rojas, and I have conferred, the state is not opposed to the court giving this defendant the credit for the time he's been in jail while this case is pending. You may recall, I've researched the issue. I actually briefed it and I gave the court that authority.
You did.
I think you have that authority if you choose to award him that credit.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion.
Okay.
Which is just a month or so,
Right.
or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, but there wasn't a hold place for some reason.
Right.
And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will, we'll get that done, okay?
Thank you, Judge.
All right, so Mr. Jones, I am handing you the trial court certification, well, 2 things. One, showing that this was an agreement, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and thank you, probation, for being here as well. Right here, right here.
They don't X them out because it's set for sentencing, so they still put out the stuff for next week. Well, once it's taken care of, they remove this stuff.
Good grief, I just wrote 2023.
I was right.
2028? Great. At least I'm making us younger, not older. What is this? First. All right, ma'am, good morning. Are you Melissa Taylor?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
So moved.
I'm going to take judicial notice of the court's file Ms. Taylor was evaluated for competency to stand trial. Dr. Capon did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Capon that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that I've visited with her a couple of times out at the jail and again this morning, and I believe that she's mentally competent.
All right.
I can't say that there's no evidence of mental incompetency because I think that there was at one time the evidence, but there's been none that I've observed that would lead me to think that she's currently mentally incompetent.
All right, and Mr. Nichols?
Nothing to add, Your Honor.
All right, then, based on the report and Mr. Kimmler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now, Ms. Taylor, in cause number 24 DCCR 2177, you're charged with second-degree felony offense of assault on a peace officer from October 2nd of 2024, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
That would be correct, yes.
All right, and in cause number 24, DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024, and how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
I did.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them
I made a
concurrently.
recommendation for 12 months on that case, Your Honor, and the defense had made a recommendation for probation concurrent with this one day.
Okay, so in essence, a cap of 12 months then? Would
Yes,
that,
Your Honor, that's fair to say.
It's concurrent.
with everyone's permission,
Yes,
can I make that? So it would be a cap of 12 months on that state jail case. Do you understand?
Yes, ma'am. And that's for the
One of the buildings.
No,
No, it's for a credit card. So what that means is that if we go forward this way, you're leaving your punishment up to me.
Okay.
And as long as I don't give you more than 5 years in the assault on a peace officer case and 12 months on the credit debit card abuse case, then you're waiving your right to appeal. I can give you 5 years, I can give you less. It'll all be determined when I get the information at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and leaving it up to me with those ranges that you've agreed to. Is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Again, find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a precedence report.
The atmosphere in the courtroom has completely changed. What began as a sentencing discussion has now become a credibility issue. Judges rely heavily on sworn statements, signed documents, and testimony given under oath. When a defendant appears to contradict prior admissions, alarm bells immediately go off. The judge is not simply focusing on the underlying crime anymore. He's focusing on whether truthful information has been provided to the court. That's why this exchange becomes so intense. If courts cannot trust sworn statements, the entire process is undermined. The judge repeatedly points to the defendant's signed admissions and asks a direct question. Which version is true? Moments like this are incredibly damaging because credibility can influence nearly every aspect of a case, including sentencing decisions. Honesty in court isn't optional, it's foundational.
That'll give me more information about you, your cases, and then we will cut back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. All right?
I do have a support letter that I tendered to the court.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. I know. That's exactly when both of y'all do better. When she does it, I think of that all the time. All right, sir, you said Dog Wilson? Ma'am, I'm sorry. I was looking at the down this way and not at you.
Seidel Wilson.
Seidel?
Yes, ma'am.
Okay. And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Let's see. I'm getting there. All right, Ms. Wilson, in cause number 2240450, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department March 14th, March 26th, April 9th, April 23rd, May 8th, and May 22nd, June 4th, and June 18th of 2024. And is that true or not true?
Yes, Your Honor.
Is it true? Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
Yes, Your Honor.
Judge, since we have an agreement.
Listen, hold on.
I'm sorry.
Thank you.
Since we have an agreement, we can drop 3, 4, 5, and 6 and just go to 7, if that's all right with the court.
Count 7 alleges that you were arrested for the offense of failure to identify a fugitive from justice and giving false information April 14th of 2025. And is that true or not true?
True.
Count 8 alleges that you were arrested for possession of drug paraphernalia April 14th of 2025. And is that true or not true?
True.
And then count 9 alleges that you were at a location other than your residence at approximately 12:32 a.m. April 14th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily?
True.
Were they volunteer?
Volunteer.
And did you, it's okay.
Yes, Your Honor.
It's all right. You're good.
Thank you.
Did you enter those pleas of true freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wilson is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty.
This section introduces an important legal concept that many viewers may not be familiar with. Criminal responsibility can extend beyond the person who physically possesses a weapon. Under certain circumstances, individuals acting together can be held accountable for actions committed by members of the group. That's why the defense attorney raises the issue of the law of parties. The discussion shifts from whether the defendant personally carried a firearm to whether he knowingly participated in conduct involving others who did. The judge also focuses on the broader facts surrounding the incident, including the number of participants, the vulnerability of the victim, and the seriousness of the injuries. The message is clear. Group violence often creates consequences that extend far beyond the actions of any single participant. Courts look at the entire event, not just isolated moments.
Of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, Your Honor.
Good luck to you, ma'am.
Thank you, Your Honor.
Are you Caprina Swan?
Yes, ma'am.
And Ms. Swan, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
Will, Your Honor.
Ms. Swan, in cause number 24, DCCR 1362, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024, and that was for the offense of aggravated robbery, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed for the months of January, February, and March of 2025. And is that true or not true? True or not? Listen to the question. Okay, true. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you admitted to using cocaine and alcohol on January 7th of 2025. And is that true or not true? Count 3 alleges that you failed to participate in the mental health services and follow all recommendations of that. Is that true or not true? Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true?
True.
And then count 7 alleges that you're behind in your court-assessed fees. And is that true or not true? All right, did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But it's my understanding that the probation department and the state are willing to give you a chance today to go to the special needs SafeP program, which will help you hopefully get all of these issues behind you, learn how to make better decisions, stop using drugs, get the mental health treatment you need so that you can be successful on this probation. I want to make sure you understand that this is your second chance now, and you will not get a third. You are on probation for a first-degree felony. Today, right now, I could send you to prison for the rest of your life. The rest of your life, from 5 years up to 50, 60, 70, the rest of your life, for violating probation on this type of offense. So you need to take advantage of everything that they teach you, because when you get out of SafeP, you'll have aftercare, you'll have people to help you, find places to live and all of that. But it's going to be up to you to take advantage of those things. Do you understand?
Yes, ma'am.
All right. I'm also going to, because you didn't report and because this is going to take some time, I'm also going to extend your probation for a period of 2 years. So you're now on a 7-year probation instead of a 5-year probation. Now, every single person who's on probation in my court and any court can get off their probations early if they do everything they're supposed to. So it doesn't have to be 7 years, but it would take you getting everything in line real quick and doing everything right. Do you understand?
Yes, ma'am.
All right, good luck to you, ma'am. You can go back with the bailiff. They're going to get some paperwork for you to sign about SafeP. You need to sign that when they get it to you.
Thank you, Your Honor.
Thank you. I don't know.
That's just doing things by itself, so.
All right, will your client waive the formal reading of the indictment in each case?
She will.
Ms. Taylor, in
This
cause,
is Ms. Woodruff.
I'm sorry, Ms. Woodruff, excuse me. Ms. Woodruff, let me get rid of that right now. Did I not? Hold on. Did I not send you both of those documents on Ms. Taylor?
I think I accidentally sent it back to you when I signed it, Jay.
Okay, there it is, back to you. All right, now, that's not going to confuse me. Okay. She'll waive the formal reading in each case.
So wait, Your Honor.
Ms. Woodruff, in cause number 24, DCCR 1710, you're charged with the state jail felony offense of burglary of a building from June 30th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they charged you with?
Yes, sir.
In cause number 25, DCCR 0426, you are charged with the second-degree felony offense of robbery from February 22nd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with?
Yes, sir.
In each of these cases, I have here on the computer documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, sir.
Do you fully understand them?
Yes.
And it looks like there is no agreement. This is just open plea to the court. Is that correct?
Correct, Your Honor.
Yes, Judge.
Do you understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is you can let them determine, obviously, if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that and leaving your punishment up to me. And is that what you want me to do?
Yes, sir.
All right, state tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Woodruff is not competent?
Your Honor, I've counseled with her and met with her on several occasions, and I believe that she's mentally competent.
All right, then, at this time, Ms. Woodruff, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Your Honor, if I may, she has a bond that was increased.
I'm not going to consider based on that plea agreement, or the lack of a plea
I
agreement.
told Ms. Woodruff I'd request.
Yeah, no, let's wait and see what happens at sentencing. Okay, you can go back with the bailiff. Okay. Good morning, are you Stephanie Moore? And Ms. Moore is on probation for robbery. There's a motion to revoke, and what's the...
Judge, Ms. Moore's been absconded for 7 years, and she's not.
Today's hearing showcased several of the most important realities of the criminal justice system. We saw defendants confronted with difficult choices, plea offers carrying enormous consequences, opportunities for rehabilitation, and the critical importance of honesty before the court. The judge repeatedly emphasized personal responsibility, reminding every defendant that while lawyers, prosecutors, and judges can provide guidance, the ultimate decisions belong to them. We also witnessed how prior convictions can dramatically increase punishment exposure and how credibility issues can quickly become central to a case. In the end, the courtroom's message was straightforward. Informed decisions matter, truthful statements matter, and actions have consequences that can last a lifetime. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns right here on the Judge Talk.
Been picked up. I almost just don't really know how to proceed because we have no idea what's been going on with her for 7 years. I'd like her to have an opportunity, if she chooses to tell the court what she's been doing before we really make a recommendation here. Obviously, she can choose not to, but...
Mr. Rojas?
Judge, I've spoken with Ms. Moore. She's told me what's been going on for the last 7 years. And she would like to tell the court where she's been, how her life's been going on. So, Ms. Moore?
I've been in a bad domestic relationship and was not allowed to pretty much do anything. Put up a mailbox, don't get any kind of medical help, get an ID. When I just got strong enough to leave that relationship. I put up a mailbox, got some health insurance, and realized that I needed to get my driver's license back and be, I have to take care of my past, and this was my past, and he wouldn't let me do that. I asked him over and over again to help me, support me behind this, or come at least drop me off at the jail so I could take care of this, and he, just the way we lived and the way he lived, it just wasn't something that was able to do. When I did try to leave, he killed my cats and pulled me back to the house. I broke my wrist. He broke my wrist this last time, and I just fled to the cops and screamed out of the neighborhood. And the cops came, and I ran to him and just said I need help. And so I knew this was here, and I knew that I had to take care of whatever I needed to do to put this behind me, so that I want to live a normal life and have my license and go get a job and have a home and a mortgage and land. And I'm 48 years old, about to be 48 years old, and I just want to get my life back without that.
So,
She was ordered to safety back in 2018 and did not report.
No, I went to safety. I've done safety.
In 2018?
No, I did it when I first got.
She was ordered back in 2018, after I think having done it around 2012.
okay.
They haven't heard or seen from her since, so.
Hold on. So here's what I would say. The only thing I would know to do is go through the motion, get an updated report that would include substance abuse assessment, where we are now, more information about all of that, and then we can see what our options are. I mean, the motion has been holding it open, and so what can I do from 2011 if the motion's holding it open? I mean, I don't know that I can extend because we're past
She started probation.
2011, December 2011. I guess what I would like to do as part of that update is just for the probation department to give us whatever options there are, if she can be extended. Now, I do know we can convict and then do a straight probation, I think would be an option. I don't know if, so if you want to do that, talk to her about it.
Sometimes talk to her.
Yeah, y'all visit, and then we can just go through the motion, get the pleas of true or not true, let probation do a more detailed visit and figure out what's been going on and where, and maybe confirm some of those things, and then we can see what our options are when we come back for sentencing. It's the only thing I know to do.
I agree, Judge.
Okay.
It's a unique situation, and I'd like to hear from probation.
Sure, okay. So to visit with her, if y'all want to do that, we can go through the motion today, and then we'll see where we are, okay?
Thank you.
Okay, again, ma'am, you are Stephanie Moore?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Just a second to get it pulled up. Okay. Ms. Moore, I have before me a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 8th of 2011 for the offense of robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department January 2nd, January 24th, February 6th, and February 22nd of 2018. And is that true or not true? True or not true?
I'm sorry.
That's okay. And then count 2 alleges that you provided a urine sample September 19th of 2017 that tested positive for methamphetamine. And is that true or not true?
Yes, ma'am, it's true.
And then count 3 alleges that you were behind in your court-assessed fees. And is that true or not true?
True, yes, ma'am.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am, I did.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. Revoke your probation. I'm not going to do that today. I'm going to reset your case like I talked about before. We'll get the probation department to do an updated or a pre-sentence report, see what's been going on, give them all the information. Then we'll come back at a later date and figure out what we can do.
Yes, ma'am.
All right.
Thank you.
Yes, ma'am. You go back with the bailiff.
Thank you. I need to print her.
Thank you, Ms. Malfino. All right, sir, are you Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor.
me just a second. Mr. Jackson, in cause number 20, all right, y'all marked third degree on the paperwork, but the indictment says second. I just want to make sure it's marked correctly.
I just looked at it sideways.
Okay, so that should be second degree?
Yes, Your Honor.
If with everybody's permission, I'll make that change on the paperwork?
Yes.
Okay.
And apologies for my handwriting, because it's horrible.
It's hard on the tablet. You're good. All right, so you're charged in cause number 25 DCCR 0114 with the second degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment like ISF or something like that, and it looks like that's what the state's going to be requesting. Do you understand?
Yes, ma'am.
And that decision's up to me when we come back for sentencing.
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to recite your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick, jail incident reports and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with a co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment of if that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been absolutely ridiculous acting up in the jail.
Yes.
So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect